Hello, we're back again following another day of the Chauvin trial. Before I get into a lot of discussion about the testimony and the evidence today, some of the questions I got or comments made regarding some of the postings I've done, it might be good for me to talk about the charges themselves. First of all, the one charge Mr. Chauvin is charged with is second-degree murder. In Minnesota, under their statute, that's second-degree murder is the killing of one human being by another, either with the intent to kill, but without premeditation. That means you intended to kill somebody, but you didn't give it a whole lot of thought. You didn't have time to weigh the consequences of the action. Or it occurs when some other criminal act is taking place and a death results from it. I think the theory here is that by kneeling on his neck, that constituted some type of a form of assault. Okay? And with that assault and the death resulting, that's how they're trying to get to second-degree murder. That carries a maximum penalty of up to 40 years in prison. The charge that had previously been dismissed but was reinstated was the third-degree murder charge. That is a death without intent to cause a death, but by some act or putting someone in imminent danger or showing a depraved mind or without regard for human life. And I think that carries a maximum penalty of up to 25 years in prison. And clearly here, I think the timing in which Mr. Chauvin had his knee on the neck, causing the death, not checking on him, not taking a pulse, not doing any CPR and all these life-saving things we hear them talk about, and that there's a policy within the Minneapolis Police Department. I think that's where they're trying to use to get to the third-degree murder conviction. Some people have asked about manslaughter. Like in Michigan, manslaughter can embody a lot of different acts or actions that take place. The most common one we know about, or at least we hear about when we start out in law school, the criminal law course, is the heat of passion, and that there was no time for the blood to cool. So let's say, for example, you come home and your spouse is engaged in a sexual act with another person. You walk in, you see it, you pick up a knife or a gun or a skillet or whatever it is, and you hit the person, and they've died. It's like one continuous act, okay? And it has to be something that would provoke a person of ordinary self-control to act out of it. So that's one situation in which that could have occurred. There are a number. It could be something that's accidental. There are a number of other little variables that come in. I'm not quite sure how that may play out here in this particular case. Generally, while it is defined by statute and there is a jury instruction on it in Michigan, generally I've found in cases I've tried, if the jury came back with a manslaughter conviction where the person was initially charged with open murder or first-degree murder, open murder, they could find first, second, or manslaughter. Usually that's a compromise, okay? Usually that's a compromise the jury has come to get a conviction to get something. They may feel first degree wasn't there. They may not necessarily be easy about the intent issue, and they start talking manslaughter, and that seems a little easier, and they, let's go with that, and there they go. Okay? So I think you have to kind of keep that in mind as you listen to some of the testimony, and it may help viewers in figuring out where each side is going. Obviously, the defense would try and show that there was no intent. A lot of the discussion on the crowd and discretion and critical thinking and what he was thinking is probably to negate a depraved mind type of scenario, which would be for third degree. Okay, so just keep those things in mind as you listen to some of the testimony. And some of you have written to me, and don't start talking about what if they come back with this or come back with that. You got to hear the evidence. The one thing, though, of course, as I said before, is without being able to see the jury, you can't tell what they think is or isn't important. Okay. Anytime I was in a trial, I'm always looking over at the jury, not only when the prosecutor is questioning them, but when I am questioning them. You kind of get a sense of, what they feel may or may not be important. If they're all sitting there with their hands folded, looking like they'd be somewhere else on a particular line of inquiry you're using, you need to move on. Okay? Get to another area. So we don't have the benefit of that because for security and privacy reasons, they're not showing the jury on camera. The second thing that happened today, prior to the trial, there was a hearing on whether or not the gentleman who was in the car with Mr. Floyd and who even went in the store at one point will be called to testify. Apparently, both sides have subpoenaed him, and through his attorney, he has indicated his intention to invoke his right to remain silent, or the Fifth Amendment. This is a gentleman, if you remember, Mr. Floyd's girlfriend said he was buying drugs from. Well, the judge has asked the attorneys to brief the issue, and I guess he'll make a ruling on Thursday as to whether there might be some areas he could testify to. And I think he even told the defense attorney, well, give me a list of questions you want to ask. I don't understand that. I really don't. Generally, if someone is going to take the Fifth Amendment, you don't even call them. Why call them to the witness stand? Hey, you don't want them to. They can't testify to some things and not to others that claim the Fifth. It's just not done. Apparently, the prosecution does not want to give him blanket immunity, from any testimony that might incriminate him, more than likely in drug dealing or drug selling, because that's the first question somebody wants to know. And other than that, I'm like, okay, so what does he bring in terms of testimony? What is he going to say? The guy was high? Well, the kid in the store said he thought he was high. Okay? How that relates here, I don't know, because if the police thought he was under the influence of some type of substance when he was passed out, or clearly he was non-responsive, they carried Narcan. They could have used it. They didn't. They never said to EMS, we think he's under the influence of drugs. At least they didn't say it when they first came on the scene. They never said it to the sergeant who's coming out to investigate on the evening this took place. So I don't know what this guy has to offer, frankly, and my position is, frankly, if you're not giving me immunity, I'm not testifying to anything. That would just be my advice to my client. You got nothing to say. We got no immunity, we're not talking. Now, so what we had today were the prosecution continuing to call witnesses from the police department who did training sessions. And they go on ad nauseum about this, and then introducing these documents to show what the training sessions consisted of, and basically attendance sheets that showed Mr. Chauvin was present at these various trainings. I don't know why you got to bring all these people in to say that, frankly. Under the business records exception, you could bring those attendance sheets in. They kept in the normal, ordinary course of business. Is it part of the records? They true and accurate. You lay the foundation, they get admitted. Okay, boom, he was there. Move on. The danger is you start calling too many witnesses, the defense is going to get somebody to give him some ammunition, and I think that happened today with one of the witnesses. The first witness, Sergeant Yang, testified. He basically testified and talked about crisis intervention, that you have to be able to recognize when someone is in a crisis, and techniques to bring them down. I mean, you can get this from the chief could have testified to that, frankly. And a duty to provide medical attention. Well, we've already heard that. We heard it from the chief. The second witness was a lieutenant. He did defensive tactics, and frankly, I thought the cross-examination, and here's where I take issue with some of the talking heads on CNN. I understand they have, to me, they seem like they have a little bit of a bias going, that they're so pro-prosecution and pro-this. I'm trying to be neutral as I look through this, but I think he scored some points. They were able to show some still photos that show the knees in different positions. He was able to get the witness to say at times, while they all said, that is not a technique we teach or we encourage people to use. The one guy said it doesn't mean he couldn't have learned it somewhere else. You start opening the door and people start saying things, and they're testifying honestly, but sometimes you don't know exactly what they're going to say. And you know what? It's better to leave them off the stand. But they didn't do that. He wants to keep coming back, the defense attorney, to the crowd, the violence, and I don't know where he's going with that, because clearly there was none. Anybody can look at that, but he is making an issue, and he's got every witness saying, yeah, you got to look and consider what the crowd is doing as you're trying to make your decisions and taking in this critical thinking and, apprising the entire situation. Everyone is saying that. And the prosecution never comes back and says, well, if you look at this here, when someone stepped off the sidewalk into the street, he directed them to go back on the sidewalk or on the curb. Did they do it? Yes. Does that seem they're being unruly? Does that seem like they're being confrontational? Does that appear they're following directions of the officers? Because you know what? All that shows they didn't have anything to fear from these people. What you had was a lady who was with the fire department, and she's in her early 20s, I believe, and some 17-year-olds filming what was going on with the camera. That's pretty much what you had. And they were yelling, but what were they yelling? They were not yelling threats to the officer about harming them, killing them, beating them, let me do that to you. There was some taunting of them by one or two of the individuals, but I think it was in response to some action Tao was taking, pushing one lady back, and the one gentleman said, yeah, I wish you would push me like that. And there was some language he used that, you know what, when you're a police officer, you gotta be used to it, okay? I mean, those things happen. People are gonna call you names. It's not even criminally actionable. But I think they did not do a good job coming back with these people they were calling and asking them those specific questions to nail that down. I thought, and where it's going to go, who knows? But I thought the defense did a good job with one or two of these witnesses in getting out the points he wanted to get out. Now, it doesn't mean they necessarily apply in this situation, but you don't know what a jury is thinking. And remember, the prosecution has to have 12 people say guilty. The defense only needs one person to say, I can't make up my mind. Okay? So he's doing his job, chipping away. Yes, some of it's driving me crazy as well, because when you go back and you look at the video, you see some things that are different. But the one question I guess no one has asked at this point is, once they had Mr. Floyd in the car, though he was on the floor of the car, and I understand they didn't have him in there in restraint, why you take him back out the car? That has not been explained at this point. And perhaps if Mr. Chauvin testifies, we'll get to that. I cannot see why he would testify, but he's the only one who can answer some of these questions, and they could very well put him on the stand. But they got to spend a whole lot of time prepping him. And if he's never testified or been cross-examined, that is going to be very, very difficult for him. First, you got to maintain composure. You don't want to come off argumentative with the prosecution, and they're going to certainly try and needle you and push your buttons. I sure would, okay? If I were cross-examining him or anybody else, and anyone that's ever come to any of my trials when I was trying cases, There's a lot of what I did. I was rather good at it, frankly, getting under somebody's skin and getting a version of them out that I wanted the jury to see. But we'll see what happens. They've called an expert to testify on force as an officer, a sergeant from Los Angeles, California. And I don't know why they need him to come in and say what was done was wrong. You got the chief saying it. The chief said, no, we don't do that. There's nothing we teach. I fired them for it. And you have these other people saying, I don't know why they keep doing this. Okay. But perhaps, we'll find out as the trial continues. So we're on for the evening. It's a beautiful day here. Hope you're enjoying yours. We'll see you tomorrow.